Today marks a fairly grim day for Captain Tom's family, who will sit at an appeal hearing to decide whether or not they must demolish the new controversial spa complex which they built without full planning permission. Now, for those that don't know, it was built without full planning permission because there was a revised plan submitted which was then refused. This being after the event that it was built other than in accordance with plans originally submitted and originally approved, which will form part of my justification for my views expressed in this video. Now, my views to be expressed in this video are also somewhat grim in that I cannot really see that this appeal will be successful. Now, whilst we won't hear the outcome of this appeal for some 6 weeks, I've taken a look at the full documents on the planning portal behind this application and the refusal. I can't put them on screen for copyright reasons because you need to have permission to reproduce them to the public, but I can quote from them so as to explain it to you because it is newsworthy. And of course, I'm doing this in an educational context. Now, the reason I feel that the outcome might be negative for the family, not to preempt the inspectorate, they will of course make their decisions all without me, but the reason that I come to that view is some of the phrasing within the officer's delegated report, which is contained on the portal, which detailed why that planning should be refused in the revised format. Now, in short, the original plan was for an L-shaped building of a particular size, which I'll come to in a moment, and the new building was a C shape. So it added the extra wing. So it was a significantly larger building, and the gaps between the boundaries were different and various other things, which I'll come to in a moment. So the paragraphs that I will partially quote from this report that give me these concerns are as follows. First of all, the report said that the intended use was for the occupiers of the main house. I'm not going to name any of the buildings in this, although these are public documents and you can go and find them, but it's not my place to name the buildings here. The building that was approved under the previous planning permission was to be L-shaped. The width was to be 15.3 metres and the depth 15.8 metres. It was to be sited such that there'd be a gap of 5.1 metres and 9.2 metres between the west-facing wall of the building and the shared rear garden boundaries with properties to the north. So 5.1 metres and 9.2 metres from those boundaries. However, and this is the bit that catches my attention if I were reading these documents. Now, caveat here, I'm not a planning specialist, but I can read documents and it does give me an insight as to the mind of the writer and what a court might think in any general setting. Whilst I'm not a planning specialist, I can interpret the way this is phrased. It says here, it became apparent during the construction of the building that it was not being built in accordance with the above approved plans. It was a different shape, C rather than L, and a larger floor area. It is also sited closer to the boundaries with the adjacent road. The gap is now between 2.7, down from 5.1, and 6.2, which reduced from 9.2. And so a significantly shorter gap between the boundaries of those adjacent properties. In addition, some of the previous planting along the boundaries of the site has been removed. And so here's the bit that sparked the revised planning application. Retrospective. Following a visit from the enforcement officer and discussions with planning officers, this revised part retrospective application has been submitted in an attempt to regularise what has taken place at the site. This, in my respectful view, is they've been caught building something that shouldn't have been there and are now retrospectively trying to get permission for it. And it's not just a case, in my view, of course, it's not just a case of it's changed a bit and therefore a revised application's been put in. It's more specific in that following a visit from an enforcement officer, meaning to me that somebody has called and complained, or the enforcement officers of their own accord have noticed and turned up to examine the site or routinely inspect the site, found that it's not being built as it was supposed to be built, and therefore had discussions, and now this revised application was submitted to, as this puts it, an attempt to regularize what has already taken place at the site. Now, further down in this report, which is extensive, there are sections that talk about in what would be considered in deciding this part retrospective revised planning application. It says the planning considerations for such outbuildings are that it should not dominate the main house or be visually intrusive on the site. But concluding, now that the building is now 21 meters in width and 15 meters in depth with a height of 4.8 meters, it's a substantial building. Whilst the site and the main house dwelling is also relatively substantial, it's considered that due to the scale of the proposed building, exacerbated by a higher ground level, it would not constitute a subservient outbuilding and would be excessively prominent within the site. This is considered due to the scale that it would be contrary to the principles of good design set out within the local plans and residential design guides. And further down, it explains that whilst the building was of the same height as previously approved, it is substantially larger. The floor area previously being some 140 square meters and now being 208 square meters. So 68 square meters larger. And just while I'm editing this video, it's probably worth saying that the average 3-bedroom house in the UK is around 88 to 100 square meters in floor space. The increased portion of this is over 60 square meters, and the overall outbuilding now stands at 208 square meters, which is between 2 and 3 times the size of the average UK house. Just to put things in perspective. Back to the video. Now, in documents submitted for this appeal today, the family have said that the structure was no more overbearing than the consented building, which, in my view, I don't really agree, and it would seem that none of the neighbours think so either. The responses received from the neighbours by the planning authority amount to 23 in total, 19 voting against, 0 voting in favour, 3 making a comment, and 1 making a petition against the approval. And so what sort of grounds could an appeal of this nature be based on? Well, the principal one would be that planning permission should be granted for the breach. So it's been built in breach of planning permission, and therefore they could appeal that it should have permission, and therefore it makes everything okay. Secondly, they could argue that the breach did not occur, which obviously that doesn't apply here. Similarly, they could argue that what has occurred is not a breach of planning control, which is very subtly different, which I won't go into in this video, but clearly that is not the case here either. And then a couple of others based on time limits, which I don't think apply. Other things such as the enforcement notice was not properly served. Alternatively, that the actions required to put the breach right are excessive or unnecessary, or that the period to put the breach right is too short or should be extended. But obviously that would still result in the demolition of the building. So there's 2 potentials here, really, from my non-expert view, and that is that potentially they can argue that they should grant planning permission, and secondly, that the actions to put the breach right are excessive, bearing in mind that the now revised application is for the entirety of the building, which is now been refused, although the building, as revised, has been built. And so, as it stands, as a matter of fact, the building stands with no planning permission, which would be required for a building of this size. So, whilst the family are going to argue today that it's no more overbearing than the original plan and should be granted, the reports and the comments that I've read about this from the local authority are not particularly favourable, to say the least. Now, there have been instances where the High Court will overturn an inspector's decision to order the demolition of a house that was built without planning permission, but equally there are other cases where the court has upheld the demolition of a building that's been built in the wrong area or a graded building, such as the one in this case. And so it is a very real possibility that the ultimate decision is going to be that this building should be demolished. And so, as always, as and when there is an update, probably in about 6 weeks' time, I'll come back and talk about the decision and what might happen next, which, if the decision goes against the family, the only option would be for a judicial review, which are usually very difficult, very expensive, and take a great deal of time. But I hope you found that interesting. Please do like the video and subscribe. And as always, thank you for watching.